Bill's second reading.
Mr. Speaker, sir, I rise again to seek your permission to have read for the second time in this Honorable House the bill shortly entitled the National Assembly Election Amendment Bill 2009. And may I thank you, Mr. Speaker, and this Honorable House for permitting the amendment to the order paper that has been circulated, which allows for the second and possibly the third reading of this bill today in one sitting in this Honorable House. Mr. Speaker, this is a short bill, but it is of critical importance. The bill, Mr. Speaker, speaks to the need to amend the National Assembly Elections Act, Chapter 162. It says here, "Be it enacted by the Queen's most excellent Majesty, by and with the advice and consent of the National Assembly of St. Christopher and Nevis, and by the authority of the same as follows." Short title, this act may be cited as the National Assembly Elections Amendment Act 2009. It goes on to speak to Section 2 of the bill, and it speaks specifically to the interpretation. It simply says that unless the context otherwise requires, the act here means the National Assembly Elections Act, Chapter 162, passed very many years ago. Then I come to the third section, the third clause of this bill that is before us, and that really is the essence of this bill, because it speaks to the amendment to Section 51 of the original act. It says the act is amended in Section 51 by inserting immediately after subsection 5 thereof the following new subsections. 5A, it becomes: a candidate for nomination for election shall, before being nominated, he must, of course, meet the following requirements. A, he must take an oath to the effect that he or she does not hold dual citizenship, that is to say, that he or she is not, by virtue of his or her own act, under any acknowledgement of allegiance, obedience, and or adherence to a foreign power or state. And 2, if he or she held dual citizenship, he or she must produce proof that he or she renounced the other citizenship since the holding of the previous elections. It goes on further, Mr. Speaker, into a subsection 5B. A person who nominates a candidate for election shall be required to take an oath or affirmation to the effect that, to the best of his or her knowledge, the candidate he or she has nominated does not possess dual citizenship referred to in subsection 5A. There is also, Mr. Speaker, contained in clause 3 of this bill before us, a new subsection called 5C. And it says further that the returning officer shall be responsible for administering the oaths and affirmations referred to in subsections 5A and 5B, and to receive and approve the proof referred to in subsection 5A(b) referred to earlier. Then, Mr. Speaker, this bill continues with a clause 4. Clause 4 of this bill before us, it says, the act, that is the original act, chapter 162, is amended by inserting immediately after section 100 the following new section. And it speaks to offense of election perjury. It says here, 100 subsection A, 1, a candidate for nomination who gives false information relating to his or her citizenship contrary to the provisions of section 51A commits an offense. And it says further in subsection 2 that a voter who nominates a candidate for election and gives false information relating to the citizenship of that candidate commits an offense. It goes on in subsection 3 that a candidate or a voter who commits an offense under this section shall be liable, summary conviction, to a fine of so many dollars, not put in as yet, or to imprisonment for a period of so many years, or to both. I want to say, Mr. Speaker, further that there is a further section 5 or clause 5 of this bill, and it speaks to now the amendment of what is referred to as the first schedule. And there is a form that is referred to as form number 3. And what this bill before us is seeking to do is to replace that old form number 3 with a new form. And that new form, Mr. Speaker, if I may refer to it specifically with regard to section 59 subsection 3, it says on the nomination paper, we the undersigned voters for the constituency of a particular area do hereby nominate the following person as a proper person to serve as a member of the National Assembly of St. Christopher and Nevis for the said constituency of that area. And we certify that to the best of our belief, he or she is qualified for election as a member of the National Assembly. And it gives the name, etc., the names, I should say, the addresses and the occupation. In other words, Mr. Speaker, this form simply speaks to what would have been amended in the original act, and thus replaces what would have been the original Form 3 with a new form to ensure that there is appropriate proof with regard to one's claim of denouncing of citizenship, or renouncing, I should say, of citizenship. Mr. Speaker, why is this piece of legislation before us in this Parliament today? Naturally, it is before us because we are preparing for national elections. We have been, Mr. Speaker, told that we as a government, we as the executive, and of course, we of the legislative arm of government have been irresponsible in not vigorously pursuing what is written into the Constitution with regard to the appointment and the election of persons to the National Assembly. And I want to refer, Mr. Speaker, specifically to Chapter 4 of our Constitution, which deals with Parliament. I speak specifically to Part 1, which speaks to the composition of Parliament, and specifically, Mr. Speaker, to what I call Clause 28 of Chapter 4, Part 1, which speaks to the following. It speaks to disqualification for representatives and senators. It says, 28 subsection 1, a person shall not be qualified to be elected or appointed as a member if he is guilty or if he falls within the following description. A, is by virtue of his own act under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. B, is a minister of religion. C, is an undischarged bankrupt, having been adjudged or otherwise declared bankrupt under any law. D, is a person certified to be insane or otherwise adjudged to be of unsound mind under any law. Or E, is under sentence of death imposed on him by a court of law in any part of the Commonwealth, or is serving a sentence of imprisonment by whatever name called, exceeding 12 months imposed on him by such a court, or substituted by competent authority for some other sentence imposed on him by such a court, or is under such a sentence of imprisonment, the execution of which has been suspended. Mr. Speaker, these are the constitutional disqualifications for persons to hold office in Parliament. Today, this Parliament and this piece of legislation before us speaks only to the first. And this must be of very prominent importance for it to be first, because it says again, a person is disqualified to be a member of Parliament if by virtue of his own acts, under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. Mr. Speaker, this is the Constitution. The Constitution has to be respected. I would fail in my duty and responsibility as the Prime Minister and the Minister with responsibility for elections if I do not work from the executive with the Parliament, the legislative arm of government, to ensure that our Parliament is properly constituted. This piece of legislation, therefore, has come today because we believe it is important. We believe, Mr. Speaker, that those who go around and trump around and say that we are going to denounce or renounce or give up our citizenship of America in order to stand for elections, we are saying the time for talk is over. Let us see it by action. And let me make it clear, Mr. Speaker, sorry to point my finger, but let me make it clear, Mr. Speaker, that it is not by somebody going on a platform and speaking for 30 minutes. I went to Barbados and I took an oath and renounced my citizenship of America. I no longer hold my passport to the United States. It's not by doing that that makes you qualified, you know. It is what is in the piece of legislation that is brought to us today. You must have proof of what you have done. And for those of us who think, especially those who would be engaged in being nominated, and those who may be engaged in actually doing the nomination, they better be warned that this country will not accept mere words. We would want to make sure that just simply going down to Barbados and taking an oath is not proof, because we know that it is a process that can take as much as 6 months. And if you cannot show the certificate of renunciation, then you are in violation of this piece of legislation that comes from the dictates of our Constitution. And so you would, in fact, according to this Constitution and this law, this act, not really be qualified to be nominated, much less to be elected to Parliament in this country. the time for fooling around is over. This is a serious country with serious business. The work of the people must be done. And today we are in Parliament to do the work of the people. Nobody is going to stop us from doing what we have to do as a government. And that is why we are here. We are here to make sure that those who want to be elected must be citizens of St. Kitts and Nevis only at the time of being elected or nominated to be elected. The time for fooling around is over, Mr. Speaker. And we want to make sure that the spirit and the content of our Constitution, they are both respected. And that is why this piece of legislation is before us today. I, therefore, Mr. Speaker, would want to commend this piece of legislation, the National Assembly Elections Amendment Bill 2009, to receive the full support of this Honorable House, passed into our laws, and then we get on with the business of really getting down to our elections. The time for fooling around is over, Mr. Speaker. May it please you.
There's been quite a number of presentations made today, and I don't intend to spend an awful lot of time on this. But when it comes to the issues of the law, we must be clear, and there's one way of putting it it must be pellucidly clear. And not only must it be clear, it must be consistent, and equally so, it must be certain. We've had the section of the Constitution which has been referred to today, Section 28, and for the purposes of clarity, the spirit of this particular bill comes from that section. And for the purposes of clarity in the record, it speaks to Section 28(1). A person shall not be qualified to be elected or appointed as a member if he, A, is by virtue of his own act under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. That is the section, that is the constitutional provision which the spirit of this bill comes from. We've had a lot of presentations this afternoon which speak to whether or not they believe in what the provision speaks to, and whether or not it has any merit, and whether or not it's out of date, and we ought to be moving into the future, and so on. For the purposes of these records, I have dual citizenship. But it's not about, this particular bill is not about targeting young people. For that matter, it's not about targeting old people. It's really targeting dual citizens. This is what this is about. And all this bill is seeking to do is to make it very clear that if someone, for example, has sworn an affidavit and said he or she has renounced citizenship, and there is indeed a process that follows insofar as that is concerned, that is a process speaking to renunciation. But what it does, Mr. Speaker, it does not confirm with any degree of certainty that you have renounced the citizenship, which, what I'm convinced everybody would agree on, that is what the Section 28(1) was seeking to do in the Constitution. Not to mislead, not to create a smoke screen, not to create an impression that later down the road it's illustrated, the affidavit didn't conform with a particular section, so what I intended doing by way of renouncing my citizenship has not taken place. That is what this particular piece or bill is seeking to do. So I won't be too long about it, Mr. Speaker. What was raised, if one looks at Clause 3, Section 5A, it says, take an oath to the effect a candidate for nomination for election shall, before being nominated, A, take an oath to the effect that he or she does not hold dual citizenship. That is to say that he or she is not, by virtue of his or her own act, under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. That's clear, because you see the spirit coming from the Constitution. And then B goes on, if he or she held dual citizenship, produce proof that he or she renounced the other citizenship. It goes on, it says, since the holding of the previous elections. You'll hear later on how we would deal with that. But the issue here, Mr. Speaker, is this. Produce proof. And I think the honourable member for number 9, I think it was, I wasn't in the House at the time, made an issue, and quite a number of other presentations made today, made an issue in relation to proof. And that is the issue, and that is the mischief we're seeking to deal with. So what is the proof? And clearly the issue of proof must speak to some certificate, some proof which gives conclusive evidence from another state or country that the citizenship was in fact renounced, or there is a certificate of renunciation that clearly confirms that that citizenship has been renounced or terminated. And that is the issue. That's the proof which will be expected to be produced. That is the document that will be expected to produce as evidence to illustrate with clarity and certainty that that citizenship to which the spirit of the Constitution was speaking to has been addressed. I made mention of the issue of the process. Clearly in some jurisdictions, whether it's the US, whether it's Canada, whether it's England, whatever, there's clearly a process, and the procedures differ. Sometimes the language is different. But for the purposes of our law here in the Federation, what we're seeking here to do is to fine-tune the process and address the issue of proof being illustrated and being presented as to the renunciation of that citizenship of wherever it is. One couldn't speak to the US alone. One couldn't speak to or to Britain alone. This is seeking to speak to dual citizenship of any other country other than St. Kitts and Nevis. And that's the issue at hand. Mr. Speaker, I don't wish to labour this House too long. As far as I'm concerned, the issues have been addressed. There is the issue here of, at Clause 4, subsection 3, which speaks to the amount of provisions for a fine and positions for years' imprisonment. At the appropriate time, one would address that, Mr. Speaker, in terms of the amounts. There would be a provision made there to ensure we've taken into consideration a number of the presentations that's been made, and at the appropriate time, those would be addressed. Unless I can be of any further assistance to this House, I wish to commend the full passage of this particular bill. I think it is a very good bill and creates the sense of clarity in relation to this particular piece of law.
Mr. Speaker, I rise finally to bring to an end the debate on the bill shortly entitled the National Assembly Elections Amendment Bill 2009. And I want, Mr. Speaker, in having the second reading and in closing the debate, thank all of the members of this honorable House who have made very worthwhile, serious contributions to this bill's debate today. And when really this bill was contemplated, it was contemplated with a certain amount of reluctance and hesitancy. Because we are aware, Mr. Speaker, that there are so many of our own people who enjoy dual citizenship. But then, you see, Mr. Speaker, the bill is not about dual citizenship. I myself have 2 children who are United States citizens, one being born there and one being born here. Both of them enjoy all of the rights and privileges of United States citizens and also are enjoying the rights and privileges of citizens of St. Kitts and Nevis. So this government, Mr. Speaker, is totally supportive of our people who seek and who appreciate and who enjoy dual citizenship with regard to citizenship of St. Kitts and Nevis and citizenship of another country. A large number of our own citizens on pregnancy, before delivery, go to the United States of America. They go to their families, to their friends, and if they are able to, they deliver their children there, because on birth in the United States of America, they can then become United States citizens. In some countries around the world, this is not possible. In nearby countries like St. Martin, this is not possible at all. In Anguilla, I don't think it is possible. In the BVI, they call them Bilonger, if you are born there in the British Virgin Islands. You cannot dare claim citizenship simply by being born there. You may claim to be a Bilonger, but citizenship is acquired through a totally different means, not just by birth, at least not by birth if you are of foreign parents. And so, Mr. Speaker, we understand, and this government appreciates the fact that a large number of our citizens go abroad and become citizens. In fact, I must say to you, this government stands on record of supporting that. And that is why this bill, this before us today, is not at all about adopting or seeking dual citizenship. It is about ensuring that the constitution of the country is respected, is being adhered to. Because if we do not do it, Mr. Speaker, we can become very irresponsible parliamentarians and government. And that's why we are here. We are here to ensure that the spirit of the Constitution is being pursued. We are here to ensure that we continue to live in a highly developing, ordered society. We are not to be at all guided by the law of the jungle, where every Tom, Dick, and Harry does as he feels like. No, we are a highly developing country. We are one of the leading countries in the Caribbean region. The United Nations has attested to that. Our young people are enjoying a quality of life that is not enjoyed by their own brothers and sisters around the Caribbean region. They are able to acquire a secondary education free of cost, and this has been going on since in the early 70s. They are able to go off to university in the United States of America, anywhere they want to go in the world, once they have shown the basic qualifications and have been matriculated to enter universities abroad, because the government provides, through the Development Bank, a student loan arrangement that allows every young person having completed his secondary education to go off to study. This is a government of young people, making it possible for young people to empowered in several different ways. In fact, the statistics will show that in the 14 years that we have been in Parliament. This government has supported, through the Development Bank Student Loan Scheme, 1,767 young people going off to study. When you compare these figures with the former administration for 15 years, 171 students only. This is a government of young people. We believe in our young people. And that is why we continue to ensure that if they are to be born in the United States of America and can then acquire the privilege that we believe they are seeking, then we would encourage that. We are here today to speak about respect for our Constitution and not living with regard to the laws of the jungle. And this is exactly what is happening here. It brings me to the point as to what really caused us in this enlightened time, in a progressive country, to come to Parliament to update our laws to ensure the Constitution is respected. It is because we have been ridiculed as a government. We have been ridiculed as a Parliament. I remember what happened to the member who is presently sitting for constituency number 2. He told you earlier today he was dragged through the courts. An attempt was being made to remove him from Parliament because the opposition sought in some way to frustrate him, to undermine the service that he is providing to the people of Central Bastille, the same service that has been referred to by the same opposition people here in Parliament today. Ridiculing us, almost taunting us as if we are a toothless tiger, if you want to call it that. And then the leader of the People's Action Movement, opposition Lindsey Grant, went onto the airwaves. The government is wrong to have people in Parliament with dual citizenship. It is against the Constitution. I heard his own press release and press statement and interviews to the media. It is wrong, and his party was going to do everything within its power to ensure that those who are sitting in Parliament are removed. I remember, Mr. Speaker, hearing the leader of the PAM party said that the same minister, the same member for number 5, that he is wrong to be sitting in Parliament. He said that he has to renounce his citizenship. He said he will have to pay back all the salaries he has received since he is sitting here because he has taken money wrongfully from the government, because he should not be here knowing that he is holding dual citizenship and is violating the Constitution, Mr. Speaker. Huh? Lindsey Grant, the leader of the People's Action Movement. How dare we forget these days? How dare can we forget this? That's why we are here. Because we have been ridiculed, Mr. Speaker. And we recognize that if we are living in a progressive and enlightened age, we cannot continue to violate the Constitution in that way. And so, this afternoon, listening to the member for constituency number 5, whose presentation was painful. Painful because I think he has been pained and hurt by his own leader, Lindsey Grant of PAM. That is why it is so painful. First demanded that he resign. Demanded that he renounce. The honorable member for number 5 refused. He demanded that he pays back the money to the government that he has received. The honorable member refused. He continued to taunt, took the member for number 2 to court to prove that he is sitting wrongly in parliament. He has pained his own colleague, the member for number 5. And so one wonders, to what extent would Mr. Grant take the rivalry that he has with the member for number 5? To what extent is it going to be taken to? And this is because I believe one member is sitting in parliament and the other one is out there on the streets, hoping to get into parliament. And that is why last night, if you listen to the tapes of the public meeting from last night, the same Lindsey Grant, you know what he said, Mr. Speaker? That this parliament dares not pass this bill today. Listen to the tapes. Ask the police for the tapes. Because the court will stop us from sitting today on any matters pertaining to electoral reform. That is why I believe the member was so pained, because the court has its work to do and the National Assembly, under your leadership and guidance, Mr. Speaker, has its work to do. And so, Mr. Speaker, we are here because we have been moved by public opinion to come to Parliament to correct what has been a malpractice with regard to the dictates of the Constitution. We are not perfect, and so we believe that errors of this could be made. And that is why we came reluctantly, because the members are right. This is a practice that we have seen over the years on both sides and different administrations. We had no appetite to come here and pass this piece of legislation. Under the former Labour administration, I'm sure there were members who were sitting in this parliament who had dual citizenship and who had not renounced one of their citizenships. Under the former administration of the People's Action Movement, of course there were. I remember, for example, when Erskine Edwards wanted to run for the electoral district of St. Christopher number 1. He had to renounce his citizenship, his US citizenship. The gentleman who we call Mallet. He had to renounce. I know for a fact, and it took him a few years well to regain it after he lost the election here, because the US does not always take too nicely for people to reject their citizenship. They feel insulted when that happens. And so they gave Mallet what you call hells, using that expression. I ask for excuse of the House.
After you stay. Go ahead.
Asking for that. Gave him that, Mr. Speaker, because he had gone ahead and renounced their citizenship to become a parliamentarian here. And, as I said, the AG himself here said a while ago, he is a dual citizen. It's not about that. It's about what the Constitution says. And so we have sought advice. We've spoken to constitutional lawyers abroad. In fact, just on Wednesday, I sought consultation on this matter. Because you're right. So many of our Caribbean parliaments need to have quality human resource to serve the interest of the people. And so one does not come to this position so easily.
That's right.
It is after careful thought and consideration. But a decision had to be taken. Do we continue to violate the Constitution as a government, or do we do something about it? Of course, we are aware that Dr. Charles, who was referred to, when Dr. Charles ran and he lost, Dr. Charles was aware. In fact, I sought legal advice before he became a candidate. I, as the leader of the party, sought legal advice when it became known to me that Dr. Charles was in fact a U.S. citizen. I sought legal advice from Fitzroy Bryant, and he told me, well, the practice is loose. If Dr. Charles wins, he will have to renounce. But if there is no practice with regard to before the elections, then let us see what happens. Dr. Charles lost the elections. I tried to appoint him after losing the elections as the ambassador to the United States of America. All the letters went through. The State Department said, good citizen, we would normally accept him, yes, because he's one who has served with us, etc. But I want you to know that as a U.S. citizen, he cannot have diplomatic relations, diplomatic immunity, here in the United States of America. And so Dr. Charles opted not to accept the appointment, because as a diplomat, ambassador, he needs to have all of the trappings and the accolades of the ambassador in the United States of America. So we have been trying our best, where it is known, to ensure that we adhere to the dictates of the Constitution. Mr. Speaker, we have tried our best to put this piece of legislation together. I think the term dual citizenship is used, as was queried by the member for Nevis 9, because it is a term that our ordinary people understand. This is what the member for number 5 said. He never knew at all that he's required to do this. Maybe because of the language of the Constitution. And so we thought that we would have crystal clear, ordinary layman language, dual citizenship. And then we went on to qualify what that means. And in qualifying what it means, we took the exact words from the relevant section of the Constitution. And that's all we have done. We wanted to make sure that people from here onwards would understand what is their obligation. We have broken down the difficult technical language of the Constitution, and we have made a very simple expression, dual citizenship. And it says what that means, so that from here onwards, you can see, you know what it means by having foreign allegiance and all kind of things. It means dual citizenship. And if you have dual citizenship, this is the path that you must follow to ensure there is no violation of the Constitution. Mr. Speaker, we believe that it is going to be important for proof of the renunciation of citizenship. Because you see, what has been in the air for the last few days, making headlines, and I brought, with your permission, Mr. Speaker, the headlines for a newspaper daily here in St. Kitts. It says here, denounce U.S. citizens. It should really be renounced. Made a mistake there. PAM's leader, deputy leader, denounce U.S. Maybe they did denounce, I don't know. But what I think they meant was renounce U.S. citizenship. And then there is an interview that was given by Mr. Grant, and it would appear maybe Mr. Sean Richards, Honorable Sean Richards, that they have renounced their U.S. citizenship. And you see, we have to be very careful in people attempting to mislead the public and fool innocent people. Because if one goes down to the embassy in Barbados and takes an oath, that is not the process completed. It is just part of the process as it continues, Mr. Speaker. So we, in an enlightened country like St. Kitts and Nevis, where you have 98% literacy, can't just simply accept somebody going down and make a statement to a newspaper and said that we have renounced citizenship because we went before the Consul General, the Consular General of the United States of America, and we have renounced, and let them stop us now. This is a modern country with sensible leadership. This is not palm leadership. This is a sensible leadership at this time in this country. And proof, of course, will be absolutely necessary. And what is so difficult about the proof that is required? Because every enlightened country in the world gives a certificate of renunciation. I have asked my people in the Ministry of National Security to send to me, to Parliament, what exactly we do here in St. Kitts and Nevis as a practice. And it's here. You write a letter, say you want to renounce St. Kitts and Nevis citizenship. I mean, I want to know if people are crazy to want to renounce our citizenship, a paradise country like this. But some people do. And so you fill out an application form under the relevant act, which is the St. Christopher and Nevis Citizenship Act of 1984. You fill out a form, you make the request. It's signed and you pay a little fee and so forth. And then a certificate is prepared by the ministry and it is sent up to the minister for signature. And this is a certificate, a blank one, Mr. Speaker, as to what we do here in St. Kitts and Nevis. No one can renounce unless he has this piece of paper. He can always say, I apply. He can always say, I went before somebody and took an oath of renunciation or made a declaration of renunciation. But until it is granted with the signature of the relevant minister, you can't really say that you have renounced. Because, Mr. Speaker, it is known that sometimes when you apply for renunciation of citizenship, it is not granted. Do you know that? Do you know that sometimes it is not granted? So even though you think, especially if you're taxed, I'm telling you, even though you think you have the right to request renunciation or the right to renounce, it is not for you, as the member for number 2 said earlier, it is not for you to determine your citizenship. It's the country, it's the state. So the state has to grant the renunciation. And in particular, if you were to follow what is happening in the United States of America today, there's a whole procedure that is to be followed here. So when we hear that our friends, according to the newspaper article, went down to Barbados and renounced, after all, we must see proof. We have to see proof. The proof of the pudding is what? Is in the eating. So we have to finger it. We have to feel it. We have to make sure that this ain't really nothing that is fraudulent and false. You understand? It has to be something genuine. And that is why we are saying it here in this piece of legislation. You have to have the proof. The proof of the pudding is in eating. You have to finger it. You have to make sure it is what it said it is. Finger it and touch it. And feel it. That's what you have to do, Mr. Speaker. And that is all that we are saying here. Because this is not a stupid government. This government is not going to be fooled in any way. Because if the government is fooled, then the people are fooled. And the people cannot be fooled in this way. And so we have an obligation to ensure that there is proof. And I want to suggest humbly that the proof that is required by the returning officer as outlined in the law, in the act, in the bill, is that there be the certificate of renunciation or a document of similar intent and quality or whatever. You fellows are the ones who are the drafters. Find the right words and we put it in. You have to have proof. And then I think we had the discussions came up that maybe in demanding the proof and so forth, you are really fettering the person from being elected, and it is really going against the spirit of the Constitution. It is an unnecessary imposition on the potential legislator. The Constitution does not speak to it. But if the Constitution does not speak to it, but the Constitution says that you cannot be, but the words were, it says specifically that you are not qualified, when we have to make sure that you qualify. And how can we make sure that you qualify if we don't ask you to show something to determine your qualification? And so it is not really to in any way change the Constitution, because I think that the legal department, the AG and his chambers, they are aware as to how the Constitution can be changed. And no one is seeking here at all to change the Constitution. No one wants to ambush the Constitution to have it changed in this way. One wants to make sure that it is practical to act, as other countries are doing. I mean, you sign a certificate. I take the point where the member has said that, opposite leader of the opposition, that you may be in a failed state where you can't get documents and so forth easily, like what a country out there where they have a lot of piracy going on over there, Somalia and so forth, or Liberia, which has underwent some serious political instability, that you may not be able to. And that is why the appropriate language must be put in place. But one has to ensure that there is something to be shown, something to see, something to finger, to make sure that no one is being fooled, Mr. Speaker. And I make the point again that in my own case here, when I get a request of this kind, I usually wait for a period of 3 months before I sign it. Because just as the US government is doing here, it says that you just don't get it when you request it. In fact, the procedures as outlined according to the United States procedures is that you have to have 2 interviews. In the first interview, after you make the application, they look at your documents, they make sure that you're a real citizen of the US. Then they want to see if you are a citizen of another country. They look at your documents. they process them, and by the time you do the second interview, they give you back the documents, especially for the other country with which you have citizenship. And then they say here, I want to quote from what are the guidelines on the internet. They say, a time to reflect is afforded to all citizens after the first interview. So this time allows citizens to carefully review and ponder the information provided during the interview and decide whether to continue pursuing loss of nationality, because it's a serious step that you are taking. It is not something that is rushed off. So you can't jump on a plane today, go down to Barbados, and you come back and you say, oh, I renounce, or denounce, as the people say. It doesn't work like that. It takes time. The United States government imposed within the procedure, deliberately so, time for you to reflect, to ponder. Am I doing the right thing? Look at all the privileges that I am going to give up. And that is what I think is troubling the member for number 5. Because if he, as he said, is a US citizen and is now being called upon, it is clear to me that what is going through the mind of the member for number 5 this afternoon is, boy, am I doing the right thing? I mean, can I afford to give up this for politics? Can I give up this for the people of Sandy Point, some of whom he already said were so ungrateful? This is what the minister is, this is what the member is pondering in his head. And so the member for number 5 is presently going through a period to ponder, reflection. And this is because, you see, you cannot afford to have your cake and eat it. The people of Sandy Point need to have a representative who, if he loses, does not have the opportunity and advantage to run away back to the United States and leave them here. And that is why I think the people are saying, boy, if you really want to be with us, give up that thing here and stay with us here. That is very reasonable on the part of the people of Sandy Point or the people of any other community or constituency where this is happening. And then it says here, Mr. Speaker, that at the second interview in the United States system, the diplomatic or consular officer will witness citizens' signature to the pertinent forms and administer the oath of renunciation of U.S. nationality. But that is not it, So if that is what took place a few weeks ago, that is being announced here, that's not it. So our people must not be fooled. It goes on to say, following the second interview, cases are forwarded. This is a long process, This takes months. Cases are forwarded to the United States Department of State for review and approval, which may take several months. Not me say so, the United States government is saying that. Only after the Department of State approves a loss of nationality is a case considered complete. Upon receipt of the U.S. Department of State's determination, the U.S. Consular General will post the determination together with the evidence of U.S. nationality to the address provided by the expatriate. You hear what I call it now? Expatriate. They didn't call it your person anymore, You're expatriate. And they went on to show you why this is important. Because they outlined to you in the procedure that when you apply to renounce your citizenship, you cannot apply at the same time to hold back some or to want some of the privileges of the person who is doing the renunciation of the U.S. citizenship. In other words, they are saying to you, you either remain a citizen or you break completely. Why do I say that? I have been informed recently that you can deliberately determine the outcome of your application for renunciation by deliberately giving false information, or, as is being said here, asks for a privilege that you enjoy with dual citizenship. In the case of the United States of America, asks that it continue after you would have renounced. But that ain't going to work. And I have been told that that is what Mr. Lindsey Graham did in Barbados. Deliberately, in his application, asks that he continues to hold the U.S. passport. But you know that ain't going to be granted. So right away, Mr. Speaker, if that information I have is correct, even though he has made an application for renunciation, it will not be granted. Because in that application, I understand, he is still asking that he be allowed to retain his U.S. passport. How could that happen? That can't happen. You can't have your cake and eat it. And so all this lot of hype on the radio and so forth. May I say, Mr. Speaker, that Lindsey Graham knows that his application will not be granted. And so he will remain a citizen of the United States of America for the next elections. And he will have to show proof with regard to a certificate of renunciation. And he will not have it. So he's fooling the people of constituency number 4, because he will not have it if what I have been informed is correct. Mr. Speaker, this really is part of the web of deception that is being practiced on the people of this country by the leader of the People's Action Movement, one who is called Lindsey Graham. Mr. Speaker, the whole point is that it's a long process. And only the United States State Department, which is similar to our Ministry of National Security and Immigration, will take the final decision. Lindsey Graham or any other person applying to the United States government to have their citizenship renounced cannot determine it themselves. It has to be determined by the United States government after a long process of consideration. So again, it's attempting to fool the people of number 4 and the people of this constituency. Mr. Speaker, I believe that the bill that is before us is timely. It is timely because we have been made to look foolish. We have been ridiculed by saying we're only talking about these things, but we don't have the guts to introduce legislation that speak to the spirit of the Constitution with regard to the matter of dual citizenship. This piece of legislation is timely because it seeks to ensure that the continued abuse of the constitutional requirement comes to an end. And it, to a large extent, Mr. Speaker, confirms that though St. Kitts and Nevis, the government of this country, supports dual citizenship, we have to make sure that our citizens who want to become parliamentarians must do so according to the dictates of the Constitution, because the Constitution bars anyone who has dual citizenship to contest elections, to be appointed to positions in Parliament or elected to Parliament without renouncing their citizenship of the next country that they have. Mr. Speaker, if it so pleases you, may I ask now that this bill, shortly entitled the National Assembly Elections Amendment Bill 2009, be allowed its second reading. Before, Mr. Speaker, I think I also wanted to point out that there were some blank spaces in the bill. For example, in terms of those persons who would be charged with perjury. I want to suggest, Mr. Speaker, that in the spirit of what is already contained in the electoral amendment law, that persons who are violators in this way, that the fine should be $30,000. $30,000, and the imprisonment, according to what our previous bill has said, it should be 5 years. May it please you, Mr. Speaker. Yeah.
Second now.
Mr. Speaker, I second the motion for the second reading of the bill.
The question is that the bill shortly entitled the National Assembly Elections Amendment Bill 2009 be read a second time. Those in favor?
Aye.
Those against?
Bill to amend
the-
the National
the ayes-
Assembly Elections.
The ayes have it.